All right, I think we're going to get started here in just a minute. I see a couple more people filtering in, so I'm going to give them just a few minutes to join us, or not even that, about 30 seconds probably to join us, and then I'll get us started. Okay, I think I'm going to go ahead and get started. So, hi, my name is Crystal Dahl. I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar. For those of you who are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 250 markets around the world since 1990. Meritas capability webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may dial into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the questions module. If you do not see this section, you may need to expand it by clicking on the gray bar that says questions. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as Josh's contact details. Our webinar today will be presented by Josh Escovedo. Josh is a member of Weintraub Tobin, the Meritas member affiliate in Sacramento, California. He is an experienced trial attorney and a member of the firm's litigation, intellectual property, and real estate practice groups. Josh maintains a general litigation practice with a particular emphasis on disputes involving real property and intellectual property. In addition to those two practice areas, Josh handles a broad range of commercial litigation matters for clients in various industries, including but not limited to hospitality, real estate, sports and entertainment, agriculture, and construction. In addition to Josh's litigation practice, Josh assists clients with trademark and copyright clearance, registration, licensing, and enforcement. As a result, Josh has extensive experience dealing with the United States Patent and Trademark Office and the United States Copyright Office. Josh has also successfully handled various matters before the Trademark Trial and Appeal Board. With that, Josh, are you ready to get us started?
Sure. Can you hear me okay?
I can. Take it away. It's all yours.
Okay, great. Yeah, I actually panicked for a second because I went to mute so nobody was hearing my background noise, and I muted my laptop, and all of a sudden I realized I probably need to be able to hear when this thing gets started. But anyhow, thank you everyone for attending today. Here we'll be talking about navigating the conflict between numerous different state legislative acts and ordinances concerning cannabis and the federal law, where I think most of us know that cannabis is still illegal. So specifically, we'll be touching on how that conflict creates issues with advising and protecting your client's intellectual property if they do business in the cannabis space. And we will also be addressing the ethical issues that are implicated by providing this advice as a result of the conflict between the federal and state law. So with that said, we'll get started. As most of you know, the states have passed various acts of legislation or constitutional amendments that have varied how the state law treats cannabis under strictly under state law. So for example, and we'll be using California as our primary example today just because that's where I practice and that's where I am most familiar with these schemes. With that said, we will also touch on Colorado just because I wanted to be able to provide everyone with another reference point. And with that said, there is quite a bit of overlap between the states in terms of how the state bars treat the ethical aspects of the conflict of law. So it can really vary, but as you would expect in states like, if we look at our third bullet point, such as Alabama, Idaho, Kansas, and the like, those state bars would obviously differ greatly from the states where cannabis is fully legal, such as California and Colorado. With that said, you can always reference this slide at a later time because I think if we went through each state and its current status, it might take up about a third of this presentation. So with that said, we'll go ahead and move forward. So although cannabis is legal in various states, as we had just demonstrated on the last slide, it remains illegal at the federal level. So as you can see in the first bullet point, it's unlawful for any person to knowingly manufacture, distribute, dispense, or possess with intent to manufacture, distribute, or dispense cannabis with over 0.3% THC under the Federal Controlled Substances Act. And there have been various discussions about changing this law, but nothing has happened to date. And I don't think with the current makeup of Congress, we'll see that happen. I believe that there was recently supposed to be a discussion among Congress about what should be done with cannabis and the conflict that we're talking about today. But it was ultimately decided that there are more pressing issues facing our country today, and so they decided to table that issue for a few months. So we'll see how that comes out, and we'll also see if we're looking at a different, we'll certainly be looking at a different Congress by the time they pick that issue back up. Whether there will be any changes in the partisan makeup of Congress remains to be seen, but that could obviously have a substantial impact in how those discussions go. In addition to outlawing the manufacture, distribution, dispensing, and possessing these illegal substances, it's also illegal to possess cannabis, even if it's for personal medicinal uses under federal law. And there's a Supreme Court case. Well, I don't know if it's a Supreme Court case. Actually, I believe it's a Ninth Circuit case, and I can provide that citation if anybody's interested. But it was dealing with an issue in Oakland, and essentially the court finds that even a medicinal use does not constitute a defense to a prosecution or claim under the Controlled Substances Act. Under the Controlled Substances Act, cannabis is considered a Schedule I drug. And so what that means is it's considered to have no accepted medical use. It has a high potential for abuse, and it lacks accepted safety for use of, there's a lack of accepted safety for use of the drug or other substances, even under medical supervision. The Controlled Substances Act also says that a person who aids, abets, counsels, commands, induces, or procures the commission of a federal offense, or who conspires in its commission, is punishable as a principal to the offense. So what that means and why that matters to us for the purposes of our discussion today is that what the ethical opinions talk about is whether we can actually provide advice to our clients. And we'll get into why that comes up in these situations. But as you can already imagine, or as you may already know, the issue is the conflict between the state and federal law. So are we able to advise a client with respect to cannabis when his or her business is legal under state law, but from a federal perspective, you may be assisting or advising a client in conducting illegal business. And so we look to this particular provision with concern because from a federal perspective, if we had an aggressive AG or an aggressive U.S. Attorney's Office who was looking to target lawyers, they might argue that when we provide advice and counsel to someone in the cannabis industry, we are aiding, abetting, counseling. I mean, we're certainly counseling inducing or procuring the commission of a federal offense, that federal offense being a violation of the Controlled Substances Act. And for those of you who may be wondering, can Congress or can the federal government regulate intrastate commerce concerning cannabis? So for example, the laws of, for example, the state of California say that even if you are a licensed dispensary, a licensed grower, or whatever the nature of your business may be in the cannabis industry in California, you can't take your products across state line. The moment you take your product across state line, you have now engaged in interstate commerce and have violated federal law, as well as the state laws for the most part, which do require that the conduct stay within the state. Well, so that raises the question, does the federal government's prohibition against cannabis really, can it be enforced against people who are doing business solely within the state? And the Supreme Court has ruled on that issue long ago, and they basically said that regulation of intrastate cultivation, possession, use, and commercialization of cannabis is a lawful exercise of congressional power to regulate interstate commerce. So I don't think that's a great surprise to any of us. Most of us know that the Commerce Clause is very, very expansive, and it's only become more expansive over time. And that permits the federal government to regulate that conduct, even if, from our perspective and for purposes of the cannabis laws, that conduct is occurring solely intrastate. So here today, we're going to discuss how that impacts advising your clients on trademark issues. So most of us know that under the federal law, which is the most useful body of law for protecting our clients' intellectual property, we have to seek protection under the Lanham Act. The Lanham Act guides our ability to protect, register, and ultimately police our clients' trademarks. And so we all know that if our client has a business and they want to protect their trademark rights, most of us would forego a state registration unless there is some particular reason why we think that a state registration makes sense. And I'll be honest, I have dealt with one state registration in 8 years of practice, and that was because it was a cannabis mark. And the reason that you seek protection in the state trademark office, or here in California, the Secretary of State's office, is because of the first citation you see in front of you. It says use of a mark in commerce must be lawful to be the basis for a federal registration of the mark. That was from Gray versus Daffy Dan's Bargain Town, which is a ruling under the Federal Circuit. But it can also be derived from the Lanham Act itself, as well as the Trademark Manual of Examining Procedure, which is pretty clear that the USPTO is required to reject your application if you're seeking registration in connection with unlawful products such as cannabis. And as you can see in the next bullet point, the issue has obviously been raised because surely somebody wanted to seek these protections under federal law, and they probably argued that, yeah, the mark is unlawful under federal law, but it's lawful in the state where I'm utilizing the mark, and for that reason, I should be allowed to bypass the lawful use requirement and have my mark registered. But the TTAB addressed that issue, and they said the fact that the provision of a product or service may be lawful within a state is irrelevant to the question of federal registration when it is unlawful under federal law. So that pretty much forecloses that entire argument and anything similar to it. I mean, if it seems to be pretty clear cut, if the product or service is unlawful under federal law, then it is also not going to be granted the protection of the federal law, such as the Lanham Act's trademark protections. And here we can see a little bit more of a specific example. There's the USPTO's examining attorney will issue what people are often refer to as a CSA office action if you attempt to register a product that's used in connection with cannabis. And it's what this In Re JJ206 LLC said was, where the identified goods are illegal under the Federal Controlled Substances Act, the applicant cannot use its mark in lawful commerce, and it is a legal impossibility for the applicant to have the requisite bona fide intent to use the mark. So they're doing two things. One, they're saying that because the product is illegal under the Controlled Substances Act, you can't register the mark. But in the second portion of that, or the second clause of that sentence, you see that they say it is a legal impossibility for the applicant to have the requisite bona fide intent to use the mark. And I think what they're addressing there is an attempt to register the mark under an ITU basis, or an intent to use basis. And for those of you who are familiar with this, you know that if you represent to the USPTO with a sworn declaration that you have a bona fide intent to use the mark within the next 3 years, plus a number of extensions, however many you choose to use, and I believe it'll go out as far as 5 or 6, but you can reserve the mark for a later date, and your use, whenever you should choose to use it, assuming you're still within the statutory period, will relate back to the date that you filed your application. So theoretically, you could file an application today for an intent to use a particular trademark in connection with cannabis products. And if it were filed today, and let's say it was approved, let's say it's approved January 1, 2021, you will have 3 or more years to then use that mark in commerce. So I think the argument around the lawful use requirement would be, I have an intent to use it once it becomes lawful. And so you're essentially gambling that at some point cannabis will be legalized and you will have your intent to use application on file, giving you priority once the USPTO is finally allowed to register your mark. But under this particular line of authority, it says that it's a legal impossibility for the applicant to have the requisite intent to use. So if that's the case, even an intent to use application is likely to be shut down if it's filed in connection with cannabis. So that brings us to our next question. How can businesses in the cannabis industry protect their trademarks? Well, as we just discussed, the Lanham Act isn't available for us or for our clients in that industry. So that takes away the most useful and far-reaching protection provided in the United States for trademarks. So we have to figure out a workaround for now. Until cannabis is legalized, we won't have access to those protections. So there are a few things that we've done at our firm and that I've read through my studies in these materials that other practitioners are recommending to individuals or businesses in the cannabis space in order to protect their intellectual property, because as we all know, just because you can't have federal protection doesn't mean you shouldn't do something to protect your IP, because your IP might be the most valuable asset you own. And the first recommendation, and this is something that had been pretty widely advocated for quite some time, was to federally register the relevant trademarks in connection with ancillary goods and services, such as rolling papers, lighters, pipes, vape devices, cartridges, things of that sort. But your registration would have to be limited to use in connection with tobacco. If you don't make that clear, the examining attorney is going to issue a CSA office action and say you can't have these products because it would be illegal under federal law, and so I can't register your mark. You may even be required to disavow use in connection with cannabis. So, I mean, that makes sense because there is a process called bridging the gap. which some of you may be familiar with. And what that means is I have a product or service that is within a certain industry, and my products and services are reasonably related to these other products and services. And they're so reasonably related that I should be able to take the protection that I have for my trademark in connection with my goods and services and extend that out a little bit further to these other goods and services when I start using them, because it's a natural zone of expansion for my business. That's a reasonable argument, and it's something that we still advise clients on, because it is a reasonable measure that these clients should take. And that's especially true if it's a large cannabis client as opposed to something smaller and local. Not to say that they shouldn't protect their IP as well, but obviously the larger, better heeled clients can afford to spend greater sums of money to protect their marks, even if it's going to provide minimal return at this time. But the Southern District of New York recently took up a case, which is cited for you here, Woodstock Ventures LC versus Woodstock Roots LLC. And there, what they were dealing with were two companies. One is the company who is responsible for the famous Woodstock Festival and its related goods and services. Another is another brand that sells Woodstock goods and services of a different type. And these parties actually had a concurrent use agreement for quite some time, and they still do actually. But an issue arose when the defendant sought to register an application for a trademark for Woodstock in connection with ancillary products like rolling papers, lighters, vape devices, and the other Woodstock was actually licensed to sell recreational cannabis in New York. So the defendant actually filed a motion for preliminary injunction against the plaintiff, seeking to enjoin their use of the Woodstock mark in connection with cannabis. And essentially what they argued was that their goods and services, they being the defendant, were so reasonably related to cannabis related products. I mean, they were selling vape devices, they were selling lighters, rolling papers, all things that could just as easily be used in connection with cannabis as they could tobacco, that Woodstock was actually, well, the other Woodstock was actually violating their trademark rights by selling recreational cannabis. And what they said was that they didn't have a registration. Even though both sides have some federal registrations, they said the plaintiff doesn't have a federal registration with respect to the right to sell cannabis, and so we want to enjoin them from using these products, or at least from using the Woodstock mark in connection with these products. And the court walks through the Polaroid factors, which are the applicable factors in the Second Circuit. And pertinent for our purposes here, I mean, they find a number of things. One, how they're using the mark, how they present it to the consumer are vastly different. But the most important for our purposes here is that the court expressly finds that a party with a registration covering ancillary goods cannot bridge the gap. And essentially what the court said was, you can't argue that you have that it's within your natural zone of expansion to move into the cannabis industry, because moving into the cannabis industry is illegal under federal law. And because that's the case, we won't find that you can bridge the gap. And so that was a pretty significant issue in that case. And it seems to cut against some of the evidence or some of the advice that various practitioners have given to date. Now, whether all other circuits will come out in that direction remains to be seen. And frankly, whether the Second Circuit itself would support the Southern District's thinking there is also an open question. But that's just something to keep in mind when we're advising our clients. And just, it's probably worth noting that the court also, in performing this analysis, the court took notice that in defendant's opposition to plaintiff's motion for summary judgment, the defendant argued that plaintiff could not lawfully argue under federal law that it was expanding into the cannabis industry because cannabis is illegal under federal law. So really, this is one of those situations that I think a lot of us hear about and pretty frequently dismiss or just roll with the situation. But here it's a situation where they advocated one position and then they took a completely contrary position in a subsequent motion, and the court actually took notice of it, and I'd say it probably weighed against them because they said, well, you seem to admit that this is the law here, so we're going to go ahead and roll with that, and we're going to find that you cannot bridge the gap because these are illegal products under federal law. So in addition to registering a trademark in connection with ancillary goods, what we advise our clients to do, and what most practitioners are doing, is advising their clients to avail themselves of the state trademark laws by registering their trademarks with the relevant state governmental body. And that's going to vary from state to state. As I said earlier today, California, you file your application through the Secretary of State, but I've seen actual trademark offices in certain states and things of that sort. So that is one of the most common ways that you can advise a cannabis client to protect their rights. And frankly, it helps quite a bit because although there are issues with that, which we'll get to in just a minute, it seems that it would provide you with most of the protection, especially for your local or regional cannabis businesses, because they aren't going to be worried about some of the downside that we'll discuss shortly. What they're going to be concerned with, and just by nature of the fact that these businesses, for the most part, are licensed on a state-by-state basis, you're not really going to suffer too much harm by having rights that are limited to the state. And that's really the downfall of state trademark law when you're choosing between a federal registration and a state registration, is that the federal registration creates constructive notice on all parties throughout the country, and it provides you nationwide rights, whereas a state registration does the same thing, but only within the state of California or the state of New York, wherever you may be. So you don't obtain the same protections, but we'll touch on that shortly. The other thing that you can advise a client to do, and I think that this is ultimately something that you would allege as an alternative theory of liability in any complaint or in any cease and desist letter that's sent out, but you would argue that in addition to a state registration, your client has state common law rights just by nature of using the mark in commerce. It would be harder to make that argument under federal law, and there have been some people that have taken opinions that even though there is a section of the Lanham Act that permits you to sue for unregistered trademarks, you may not have protection there because it seems that a federal court may find that your use isn't lawful from a federal perspective, and so they're not going to protect your rights under federal law. That doesn't really create an issue under state common law if we're talking about making those arguments within a state where cannabis has been legalized, because those courts have no reason to find that you're not using the product in commerce. In fact, you are, since you are lawfully selling the product under state law. But I don't advise clients to rely strictly on common law, just because we all know that has some geographic restrictions. And so it gets us back to the point of so federal law we can't take advantage of, and that would give us nationwide rights. And then we cut down to state law. So that's where we end up, is with a state registration, we get statewide rights. Well, if we rely on solely common law, then we are further restricted to the areas where our clients are doing business. And so let's say, for example, you have a San Francisco-based cannabis dispensary. That if you rely on state common law instead of registering with the Secretary of State, you may not be able to stop someone in San Diego or Los Angeles who decides to use the same mark in connection with cannabis, because your use will be geographically restricted to the area in which you do business. So again, it seems just like we would tell clients who do business nationwide, you can rely on common law if you don't have a trademark registration yet, or you could rely on the Lanham Act, as I mentioned, but it makes more sense to have a registration because there are benefits that emanate from that. And here, when we get down to the state level, it's the same thing, it's just magnified even further. So you could be restricted to a city or a county, and you would much rather have the right to be able to restrict someone's use of your intellectual property in San Diego if it can be done with minimal inconvenience. And I think that that's important because there's a difference between you using a product or you using a mark in San Francisco and someone over in Maine using the same mark. If you're a regional business, your damages resulting from that arguably infringing use are probably de minimis. But if somebody in Sacramento or somebody in Los Angeles starts using the same mark as you're using in San Francisco, you could suffer significant harm because those places aren't so far apart that you may not have overlap of consumers. So that's just something to keep in mind. So here we are again talking about, and we were just covering this, but the absence of federal protection can be problematic. And so if you don't have federal protection under the Lanham Act, your use is automatically going to be geographically restricted. And as I just said, what that means on the most basic level is, whereas you could use the product in San Francisco exclusively and file with the USPTO, obtain a registration and have nationwide rights, you don't have that ability if you're in the cannabis industry. So you have to then rely on the state body of law to get your protections throughout the state. And again, as I just mentioned, you can rely on common law, but that's an even greater geographical restriction. So that is an issue. And then I think something that warrants discussion here, and I think it's sort of implied from what we've been discussing here today, is that this is probably the greatest issue with this, and it's really a product that's becoming, I mean, it's really an issue that's becoming more pronounced as the cannabis industry evolves, because now we have companies, when things first started getting legalized, we had companies that were growing and just really getting started, and so we didn't see as much of the presence of the same company in every state. As we do with most other legal businesses. I mean, Amazon's everywhere, for example. Walmart is everywhere. Cannabis, you had smaller companies, and that's just how it was. But now we have companies like Canopy Growth, for example, the Canadian cannabis giant. They do business all over the place. And so it's important that they be able to protect their intellectual property as expansively as possible. But based upon the restrictions we were just discussing, that could be problematic. So let's take, for example, let's use San Francisco again. Let's say there's a San Francisco, or let's do LA, because I can actually think of a cannabis company in LA that does primarily SoCal business. So let's take Cookies in SoCal as an example. They're doing business under Cookies in SoCal, and I don't know if they have a state registration. There's not as easy of a way to search for state registrations as there is federally, but let's say they have a state registration, but they only do business here in California. But let's say they have a plan to grow through, however long, 2-3 years from now. But in the meantime, somebody is using Cookies in Colorado in connection with cannabis services. Well, I mean, the world gets smaller every day, and surely there's a lot of overlap between Colorado and California, people traveling back and forth regularly and, seeing family and stuff. So surely there are consumers of cannabis products that maybe go to both places. Well, it's reasonable to believe that if somebody went to Colorado and they saw a dispensary or products being sold in connection with the cookies mark, they would assume that perhaps it's the same cookies that are being sold in Los Angeles. Well, that's exactly why we have trademark laws, is to protect against this consumer confusion and this false designation of origin. But the problem there is cookies rights can't expand beyond California because they're only doing business in California and they can only register under state law. They can't obtain a federal registration right now. So in that situation, there's nothing cookies can do about this other cannabis company doing business in another state. Now, that's probably an overstatement. There may be some claims that we could come up with, like some sort of unfair competition or something of that nature, but you better believe that if you brought a claim for unfair competition or something like that, that the defense is going to be, you have no right to claim that you have rights that go beyond your state. So I think that that's probably a pretty strong defense to any sort of claim. So you can see that the issue there is that you can't obtain protection in these other states. And so really it's sort of a free-for-all unless you're doing business, like for example, Canopy Growth, they're doing business all over the place. So they can go throughout the different states and just register their trademarks wherever cannabis is legal, or they also delve in the hemp industry and things like that. So they could have registrations for hemp, and then they could have state registrations for their THC based products. And that's doable. I mean, it's really no different than a company who does business in various states having to register to do business with the Secretary of State, but it's burdensome. And it's only available to those companies who are doing business in all of the states or multiple states. And sure, you might be doing business in California and Colorado, and so you might be able to get your protections there. But are you doing business in Oregon? Are you doing business in Washington, Nevada? What if you aren't? If you're not, you have no right to protect your mark in that state. And so you can see how that could be quite a significant problem. The other downside of not having the federal protection for trademarks is that there are inferior remedies under state law, and that varies from state to state. And I'll be honest, I'm most familiar with California and New York trademark law in terms of their state statutes, but I can use California as an example. As far as I'm aware, California does not provide the potential for a profits remedy. I'm also not of the belief that California state trademark law provides the right to obtain attorney's fees if you prevail. Obviously, under Sun Earth, you'd still have to prove that your case was extraordinary in order to obtain attorney's fees under federal law, but at least you have the ability to prove that. And same thing with the profits award. After the Romag Fasteners decision earlier this year, it's been clarified that willful infringement is a material consideration in granting a profits award, but it's also been clarified that it's not absolutely required. It's not a prerequisite to a profits award. So you can obtain that. I guess my whole point here is that under Sun Earth and under Romag Fasteners, attorney's fees and profits awards require a higher level of proof and showing something beyond simple infringement, but at least they're available to you as a plaintiff. But under state law, those aren't available to you. So that can be problematic. And the last issue here is that there's no constructive notice of use in other states. So as I mentioned earlier, and I think as most of us know, federal registration provides everyone throughout the country with constructive notice of use of the mark. So you can argue that somebody was aware. You certainly have an ability to ward off other people trying to use similar marks or trying to register similar marks, because as we all know, you try to register a trademark, the examining attorney serves as sort of a guard dog to get your registration and says, hey, no, I think this mark infringes someone else's registered marks, and they won't register it. So that's one layer of protection. And the other is just you can easily access the USPTO and you can run a search and say, does somebody use cookies, for example, in connection with cannabis, or in connection with, here, we're talking about legal products still, so in connection with t-shirts, and you'll get a number of hits, and you can search the results and see if somebody's using the mark. Because although there are certainly a number of actors out there who would willingly infringe upon a mark, even though they know someone's already using it, there are plenty of other businesses who end up infringing in good faith just because they didn't know about the other trademark. Because when you think about it from that other perspective, and I'm sure we've all been on that other side, no business, unless they're a bad actor, no business wants to spend money promoting their brand and building good faith in their marks just to find out that they aren't the priority user of that mark, and ultimately having to give it up because someone else has that mark. It's a waste of funds, it's a waste of effort. And so there is a benefit to be had by prudent businesses. They look into these things and try to clear their trademarks. And so that's a huge benefit of the USPTO. But that sort of notice isn't really available to us, at least not without conducting a much more in-depth search, if we just have state registrations. So that's another issue with federal protection, or with the absence of federal protection. So now we come to the ethical issues created by the conflict between federal and state law concerning cannabis. And as I mentioned earlier, I'm most familiar with California law. I'm happy to discuss any other state laws as long as somebody gives me enough time to look into it. But for now, we'll just cover California law. And like I said, I wanted to have at least one other example to discuss and to show the significant overlap. We also cover Colorado rules of professional conduct. So here, first we look to California Rule of Professional Conduct 1.2.1. And that provides that a lawyer may not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal, fraudulent, or a violation of any law, rule, or ruling of a tribunal. Notwithstanding the prohibition, though, a lawyer may discuss the legal consequences of any proposed course of conduct with a client and counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of a law or rule or the ruling of a tribunal. Interestingly enough, the rule doesn't define the terms counsel or assist. So here, just looking at this rule, it raises a question. Can we, California lawyers, advise clients who are engaged in the cannabis industry concerning their business interests? And that question comes up because this rule precludes us from counseling a client to engage or assist a client in conduct that the lawyer knows is criminal. Well, if we look at it from a federal perspective, the client who is engaging in the cannabis industry is engaging in criminal conduct from a federal perspective, and certainly a violation of law, rule, or of law, specifically the Controlled Substances Act. So it raises the question, can we advise clients in the cannabis industry without running afoul of our ethical obligations? Comment 6 to Rule 1.2.1 answers that question for us. Paragraph B to that comment, it states that paragraph B permits a lawyer to advise a client regarding the validity, scope, and meaning of California laws that might conflict with federal or tribal law. In the event of such a conflict, the lawyer may assist a client in drafting or administering or interpreting or complying with California laws, including statutes, regulations, orders, and other state or local provisions, even if the client's actions might violate the conflicting federal or tribal law. If California law conflicts with federal or tribal law, the lawyer must inform the client about related federal or tribal law and policy, and under certain circumstances may also be required to provide legal advice to the client regarding the conflict. So that really clears up the question. We have a conflict between federal and California law. Can we advise this client even though Rule 1.2.1 says that I can advise or assist a client in conduct that violates law? This answer is clear. If there's a conflict between the state law and the federal law, we are free to advise and counsel a client about the California laws and assist the client with the California laws. But in order to do so, we must ensure that we advise the client that California law conflicts with federal law. That is a prerequisite to providing that type of advice. So here we have, under California law, the attorney's permission to assist cannabis clients is not unlimited, though. The attorney's ability to assist is conditioned on his providing information about the conflict between state and federal law, which I just mentioned. And here is where we have the limitation. The attorney's permission to assist, like the permission to give advice, does not extend to assistance in evading detection or prosecution under state or federal law. So, I mean, I think it's commonly accepted that we can't advise a client on evading detection or prosecution of certain laws. But we can advise and counsel them, and it's an important and integral part of the law. And there's a lengthy discussion. It's actually it's California Formal Opinion number 2020-202, and it extensively discusses the interplay of the federal and state law and the various rules of professional conduct. And essentially, the opinion states that it's an integral portion of the attorney's responsibility to provide advice to the client on how to comply with these rules. So it's about more than evading detection and prosecution. It's this advice and counsel is necessary because we as attorneys want our clients to avoid running afoul of the law in such a manner that they would even have to consider evading detection or prosecution. So the advice is critical. I mean, that's what people turn to us for, and that's one of the great things about being an attorney is that you're helping people, and your job is actually to make sure that people are, or to advise people on the manner in which they can comply with the law and avoid running afoul of it. And so here, the formal opinion and the California rules of professional conduct provide that you can provide that advice. Colorado law is similar, if not identical, to California law on these issues. So the Colorado Bar Association said that under Rule 1.2 subsection D of the Colorado Rules of Professional Conduct, an attorney may represent and advise a client about the consequences of marijuana-related activities, advise a client about establishing, interpreting, enforcing, or amending zoning, local ordinances, or legislation, and advise the client about the tax consequences of growing or selling marijuana. On March 24, 2014, Colorado adopted Comment 14 to Rule 1.2, and Comment 14 states, a lawyer may counsel a client regarding the validity, scope, and meaning of Colorado's constitutional cannabis provision, and may assist a client in conduct that the lawyer reasonably believes is permitted by these constitutional provisions and the statutes, regulations, orders, and other state or local provisions implementing them. In these circumstances, the lawyer shall also advise the client regarding the related federal law and policy. So I think we can all see substantial overlap between California's Rule 1.2.1 and Colorado's Rule 1.2. Similarly, we see a significant overlap between Comment 14 to Rule 1.2 in Colorado and Comment 6 to Rule 1.2.1 in California. They pretty much provide that the lawyer can provide the same services to the client in the cannabis space, and they both provide that the lawyer is required to advise the client regarding the related federal law and policy. And I think in addition to just ensuring that your client is fully informed about his conduct and understanding how to comply with the state law, the requirement about the conflict between federal and state law is also to ensure that attorneys are notifying their clients that there is a conflict between the federal and state law, and so that they understand you are engaging in lawful conduct under state law, but you need to understand that under federal law, that may not be the case. I mean, it's certainly not the case, but whether the feds choose to enforce that or not remains to be seen. But you need to provide that information to the client, not only because these rules require you to, but so that your client can make an informed decision on whether they want to bear the risk of federal prosecution, however remote or likely that may be. So in the past, the United States District Court for the District of Colorado has generally approved Colorado's rules of professional conduct without question. Here it didn't. The district court actually said that they disagree with the Colorado rules of professional conduct, and they had said that they would only permit an attorney to advise the client. So if we look at the rule and its comment and compare that to the statement of the district court, and subsequent discussions have determined that that should be interpreted to mean that the attorney cannot assist the client in any conduct. So I'm not really certain how that works in practice, but to me it seems like the attorney can provide advice and counsel on issues, but it almost sounds as if the attorney cannot provide actual assistance with certain tasks. So I mean, I would be really curious to see how that's been, or how that works. I mean, not even, it may not be something we see in an opinion, but I'd be curious to talk to a Colorado cannabis practitioner and hear how does the district court's mention of that rule, I mean, and it may not play a role at all, but how does that impact the manner in which you provide advice and counsel to your clients? And I suspect that many practitioners would say they follow the state law and don't necessarily give too much credence to the district court's comment, but I would also suspect that there are probably some attorneys who really limit the scope of services that they provide to the cannabis industry to avoid running afoul of federal law. But at the same time, maybe there aren't that many, because really, if you're worried about the federal law, I mean, the same argument can be made here in California as well, even though our district court hasn't come out and said what the Colorado district court has said. At the end of the day, what the advice and counsel may still be construed differently under federal law, because technically the client, well, arguably I should say, the client is being advised and counseled on violations of the federal law. And obviously some tasks would be more problematic than others, because I think there are criminal defense attorneys out there. So there are people that regularly advise and counsel clients on what has occurred and what's lawful, what's not. The question, I think, the dicier area is, can you assist and help conduct their business through the preparation of agreements, contracts, negotiations of deals, things of that sort. I think that's where we get into a much dicier area. So it seems like California and Colorado law are almost identical in that regard. So it seems we've almost run the full hour. I wanted to save a few minutes for Q&A in case anyone has any questions. If you don't come up with any questions here, you can feel free to email me later, especially if it's something that's related to another state that I may not be familiar with. I'm happy to take a look at it and talk to you about it. But that's what I have for you. So thank you for attending. And just if anybody has any questions, I'm happy to field them now.
Thank you, Josh. I'm just gonna mention a couple of things here really quick as we wait to see if any questions come in. I wanted to remind each of you that I will send out a follow-up email in the next few days that will distribute a copy of Josh's presentation, as well as a recording of the webinar and Josh's contact details. Like he said, please don't hesitate to reach out to him directly if you have any further questions. Also, feel free to share the recording of the webinar if you have colleagues or friends that might find it of interest or valuable. You're more than welcome to do that. And I think I'm not seeing anything come in, Josh, so I think I'm going to wrap things up. Does that sound okay?
Sure does.
Okay. Well, thank you, everybody, again for joining us, and thank you, Josh. That was wonderful. You definitely have a good grasp on this subject, and I could tell you're a great presenter. with that, thank you again for taking the time to join us, and I hope everybody has a really great day. Bye.
Thank you, everyone.